Okay, so this is a bunch of like correspondence back and forth between Epstein's attorney and the basically the prosecutor for Palm Beach County for Palm Beach, Florida. So anyway, let's see, Adderby, Goldberger, Richardson, and Weiss, PA, 250 Australian Avenue, One Clar or Clear Lake Center, Suite 1400, West Palm Beach. Fax transmittal cover sheet date June 16th, 2016 or 2006. I'm sorry. To Lana Belalovic, Esquire, fax 355-7302. Who the hell faxes anymore? Now everything's email, but whatever. Uh, from Jessica Cadwell, assistant to Jack A. Goldberger, Esquire, regarding Epstein. Remarks total pages is 8, including cover sheet. Please note confidentiality warning. Okay, don't worry about that. It's nothing. Okay, so by hand, Belalovic. Okay, dear Miss Belalovic, regarding Jeffrey Epstein, as a follow up to our meeting of June 1st, 2006, held in an attempt to resolve this matter, we write to address the following issues which have arisen: the risk for the client to plead to aggravated assault in Florida, that he might be subject to sex offender registration statutes in other jurisdictions now or in the future, the nature of the charge of felony aggravated assault with intent to commit a felony, and how it does not reflect the allegations herein, and whether a felony conviction itself is justified based on the available evidence. At the outset of our June 1st, 2006 meeting, we were mindful that an understanding had been reached with prior counsel. It was reached, however, with the clear and joint understanding that the client would not be subject to sex offender registration requirements in any state or foreign jurisdiction. Moreover, the limited time, sorry, that's going up. The limited time provided did not allow for an opportunity to conduct an even cursory investigation or research into the ramifications. Were any charge to be brought, having now learned of the serious danger a plea to felony aggravated assault presents with regard to sex offender registration, coupled with the facts presented at our meeting and outlined below, we strongly believe that a plea to misdemeanor solicitation is the more appropriate resolution. As we discussed, this could include an agreed upon allocution, as we are mindful of your concern about labeling the girls prostitutes. In this regard, as we discussed, the law and relevant statute are clear that the complaining witness need not be a prostitute in order to satisfy the elements of the offense. One, so Miss Belalovic or whatever, page 2, an aggravated assault conviction might subject the client to sex registration. There is a likely risk that a plea to aggravated assault, FSA subsection 784.2 or 021 1B, will expose the client to registration obligations under Megan's Law, either as currently written or as likely to be amended or expanded in the future in a number of jurisdictions, including but not limited to one where he lives, works, or spends time. This is true regardless of whether the plea expressly specifies that the felony he had the intent to commit was lewd and lascivious behavior under FSA subsection 800.04 or sexual battery under FSA subsection 794.011. As my client is a full-time resident of the Virgin Islands, the most immediate and obvious unintended result of a plea of felony aggravated assault is a possible registration in this place of residency. The Virgin Islands Statute 14 VIC, subsection 1722, its sequence, I guess, is very broad, imposing a duty to register upon a person convicted on or after July 1st, 1994, of a criminal offense against a minor. 14 VIC subsection 17 or 1722A, emphasis added, under section 1722C, a person convicted as a federal, military, or foreign court shall have the same duty to register as any other person under the statute. Failure to register as a crime. 14 V.2 subject or subsection 1722 D. Further, while the Virgin Islands registry is currently accessible only to law enforcement, there are ongoing discussions about opening it to the public. See Virgin Islands Daily News, May 15th, 2006. That's interesting. I may have to go back and look at that. Okay, under current law, a plea to aggravated assault will also likely subject the client to registration in his secondary domicile in New York. The list of registrable offenses in New York under the Sex Offender Registration Act is a long one, which continues to grow. In 1999, 8 new offenses were added to the list of registrable offenses. And again, on March 11th, 2002, 7 new offenses were added. Well, don't be a creep. Page 3, in New York, a person must register as a sex offender if they are required to register in the jurisdiction of conviction or if convicted in a foreign jurisdiction. His conviction there meets all the essential elements of New York's enumerated sexual offenses. See NY Correction Law, subsection 168.1.2a 1d3. In spite of the statutory reference to essential elements, some New York courts have looked at the facts underlying the offense of conviction rather than the formal elements of the offense in determining whether registration is required, each finding that a defendant was required to register on the basis of the underlying conduct, even though the essential elements test was not satisfied. See People versus Burden, 6, miscellaneous 3D 1033A, supplemental, whatever, I guess. CT, Bronx City, 2005, People versus Millen, in 2001. The same serious concerns arises in other states, including California and Colorado, which authorized courts to look behind the plea and beyond the formal elements of the offense of the conviction and enable them on a case-by-case basis to determine if registration is required. Like New York, California requires an individual to register if they are required to register in the state of conviction or pursuant to CA Penal Code subsection 290A2DI. If that individual since July 1st, 1944 has been or is hereafter convicted in any other court, including any state, federal, or military court, of any offense that, if committed or attempted in this state, would have been punishable as one or more of the offenses described in subparagraph A. The wording of the statute leaves open the possibility that in determining whether the offense would have been punishable as one or more of the registrable offenses, one looks at the underlying facts and the formal elements of the crime to which the defendant pled. The registrable California offenses include commission of any lewd or lascivious act upon or with the body of a child, where the child is 14 or 15 years of age, and that person is at least 10 years older than the child, with the intent of arousing, appealing to, or gratifying the lust, passions, or sexual desires of that person or the child. California Penal Code, subsection 288A(c)(1). Thus, an aggravated assault plea may subject the client to a registration requirement in the state of California. Colorado likewise has a very broad statute. It requires an individual to register within 5 business days of becoming a temporary or permanent resident of the state if, among other things, the person has been convicted in Colorado or any other state of an offense involving sexual behavior or an attempt, solicitation, or conspiracy to commit such an offense, or if they are required to register in another state or jurisdiction for a sex offense. CRSA subsection 1622, 103, 1622, 108. With regard to Florida, as you know, it It is reasonably clear that under Florida's current version of Megan's Law, a plea to aggravated assault would not subject the client to registration in Florida since it is not included among the state's enumerated sexual offender offenses. This is page 4, CFSA, subsection 943, 0 or dot 0435 and 784.021. However, the offense of sexual battery is on the list as well as a charge of lewd and lascivious behavior. So there's no reassurance that in the future a Florida prosecutor or court will not take the position that where the aggravated assault is combined with what some states have labeled a sexually motivated intent, registration is required. Moreover, as you indicated at our meeting, there is no guarantee that the Florida legislature will not expand the category of persons subject to Megan's Law and expressly make persons convicted of aggravated assault subject to the law, especially where the felony the actor had the intent to commit is a sexual offense and the victim is a minor. The trend today is toward expansion, not contraction, of these kinds of statutes, and as you noted, Florida will be no exception. CEG, sex offenders, no more escaping registration. 36 McGregor, L. Rev. 822-2005. Over the last 20 years, expanded registration requirements, enhanced penalties for failure to register, and public notification provisions that have enlarged the scope of sex offender registration laws. See news articles of just this past week, infra describing many of the prescriptions being adopted around the nation, and the ex post facto clause stands as no significant bar. C. Smith versus Doe, 538 U.S. 84, 2003, upholding Alaska Sex Offender Registration Act against a challenge that its application to persons whose offenses were committed prior to its enactment would violate the ex post facto clause. If this trend continues, it is likely, as it likely will, the client will almost certainly be subject to sex offender registration. Even if the client is not and will never be subjected or subject to registration requirements under Florida's law, a plea to aggravated assault under the circumstances of this case could subject him to Megan's Law requirements in other jurisdictions. Thus, if the client pleads guilty to the proposed aggravated assault charge, there is a grave risk that under existing state and Virgin Islands law, quite apart from future expansion or expansive construction of those laws, he will be subject to sex offender registration requirements and or criminal exposure for failure to register. There is an even graver risk still that there will be future expansion of the statutes or expansive construction of them, that mean he is covered or arguably so. CEG Cherry Hill Sex Offender Ordinance upheld. Courier Post, June 1st, 2006. And anyway, so sex offenders sue city over park and pools. Well, like I said, don't be a creep. So page 5. Indeed, as you recognized during our meeting, many people who are advised by competent counsel to plead guilty to offenses when registration was not required have now been horrified to find themselves subjected to registration laws enacted or expanded after their guilty pleas without any recourse. C. Smith versus Doe, Supra 538, U.S. 84. Finally, although there is some risk that even a plea to a misdemeanor charge could trigger registration in some jurisdictions, our research suggests that this risk is considerably lower for a misdemeanor plea than for a felony plea. Aggravated assault is generally considered a violent felony and does not apply to the facts of this case. Assault is generally considered an act of force. It creates in the victims a well-founded fear of imminent violence. Velasquez versus State, 654 SO 2D 1227, 1228, Florida, I guess 2D, DC 8 in 1995. The general public is certainly not aware of Florida's unique, nuanced definition. Indeed, as you will agree, in common usage, aggravated assault on its face sounds inherently violent. Thus, at the very least, most people would consider an aggravated assault charge, even of the intent to commit a felony variety, to be a violent crime. In this regard, undifferentiated aggravated assault is one of only 4 crimes listed in the FBI's Uniform Crime Report violent crime category. More importantly, as noted, this crime clearly does not reflect what allegedly occurred, since there has been no suggestion that a threat of serious bodily harm was made or a deadly weapon used. In addition, most pleas are downward. The defendant agrees to waive his right to trial in return for the prosecution's offer of a downward departure in charging or sentencing. Further, in the typical case, a plea involves crimes that bear a close resemblance to the underlying events. The facts herein obviously do not support a charge of aggravated assault, thus a plea to the same would be inappropriate. So page 6, since the meeting on February 16th, 2006, when misdemeanor charges were initially discussed, the state's case had gotten considerably weaker. At the February 16th, 2006 meeting, you suggested the office was investigating a felony, and you indicated you would consider pleading it down to a misdemeanor. As you're aware, since then, much has happened, which makes the alleged case considerably weaker and undermines the credibility of the witnesses upon which it was based. Indeed, as you already know, the following information has come to light, severely damaging the reliability of the witnesses, redacted background, including a history of theft, confessions, and repeated denials of stealing from employers and customers, lying about her age, sexual promiscuity, and prostitution, redacted boastful admission of drug use, underage drinking, sexual activity, shoplifting, wild exaggeration of her income, at least $250,000, representing herself naked on a website, and as 17 years old, then 16 and 15, only charging it to her truthful age, or only changing it to her truthful age, coincidentally 4 days before the last scheduled grand jury. In addition, as you have acknowledged, she was found in an inappropriate place in Georgia after the police were called when she ran away from home. This is why is it going like that? This is separate and apart from the Florida police report presented to you, detailing her being dropped off by the local drug dealer at 5:45 a.m., only 2 days after returning to West Palm Beach. Look through the miscellaneous documents and you'll see all of the police report for this. It doesn't give her name, obviously it's redacted, but this is describing something that was in those documents, and I just did it yesterday. So anyway, only 2 days after returning to West Palm Beach and being described by the officer as clearly on drugs, and both of redacted's parents' criminal history of fraud. In stark contrast to this is the fact that, as we indicated at the meeting, the client has passed both the rigorous lie detector test conducted by the most highly qualified expert we could find, one whose reputation is beyond reproach, and provided you copies of 2 psychosexual evaluations prepared by experts that you have agreed are well recognized and accepted by the state. Page 7, the conclusion. Under the circumstances of this case, a plea of felony aggravated assault is both unwarranted and presents a grave risk the client will be brandished a sex offender, bearing the attendant burdens inherent with that classification. In light of this and the credibility issues presented by the complaining witness, combined with the client's 2 psychosexual evaluations and lie detector tests, We believe that the very most a misdemeanor plea to solicitation is appropriate. Very truly yours, Gerald B. Left Court. And let's see, I wanted to see. Okay. So I thought that was going to be another page. It said 8 pages, so that's why I was looking. But anyway, I will talk to you guys later. Have a good afternoon. See y'all. Bye.